Are you worried that filing bankruptcy here in New Jersey means losing your car? In the next few minutes, you'll see why most people don't lose their car at all and how you can make sure that you don't either. Here's what we're going to cover in this video. First, we'll talk about whether you can actually keep your car when you file bankruptcy and what really happens under the law. Next, we'll look at what to do if you still owe money on it, your options for keeping the car, giving it back, or working something out with the lender. And finally, I'll show you what steps you need to take to make sure your car doesn't get repossessed or sold by the trustee after your case is filed. By the end, you'll have a clear plan for how to protect your car and move forward without that stress hanging over you. A lot of people think that the moment they file bankruptcy, someone's going to show up at their house, either the trustee or the bank, and take their car away. I hear it all the time. They picture waking up to find it gone, even if they've been making their payments. But that's not how it works. In fact, for most people, bankruptcy is what helps them keep their car, not lose it. So before you make any assumptions or panic about what's going to happen to your vehicle, let's take a few minutes to break this down and talk about how to make sure your car stays exactly where it is, in your driveway. Filing for bankruptcy doesn't automatically mean you'll lose your car. The bankruptcy system is designed to give people a fair chance to start over, and that includes keeping essential property like a vehicle. There's something called exemptions. These are legal protections that let you keep certain assets up to a certain value. In New Jersey, most people use the federal exemption system, and in many cases, their car is already protected because it isn't worth that much or because they owe the bank more than it's worth. If you're still paying off the loan, it's not the car's full value that matters. It's the equity, meaning what the car is worth minus what you still owe. If the loan balance outweighs its value, your car is usually protected. Now let's look at the most common real-life situation. You still have a car loan. When there's a loan balance, it actually helps protect the car because that balance lowers its equity, often bringing it well within the exemption limit. From there, you've got three main options under the bankruptcy code. First, surrender the car. You can give it back and walk away from the loan entirely. There's no liability for any repossession deficiency later. Second, pay off the remaining loan balance. This is called redemption. If you owe only a small amount and can pay it off, you can do that and keep the car free and clear. Third, you can reaffirm the debt. That means signing an agreement to keep making payments on the car loan even after the bankruptcy so you can keep the vehicle and maintain your payment history. The downside is that the loan will not be discharged in bankruptcy. You'll still owe it after your case is over and can never discharge it later. So if you reaffirm a loan you can't really afford, you could end up owing thousands again if the car gets repossessed after bankruptcy, basically wiping out your fresh start. For that reason, reaffirmation isn't something to rush into. It should be done only after careful thought. Make sure you can afford the payment going forward. Also, some lenders allow you to pay and ride, which means you just keep making your regular payments without signing anything new, and they're fine with that as long as you stay current. I once had a client who was sure she'd lose her car after filing. She was still making payments, and the thought of losing it terrified her. We worked through her options, she reaffirmed the loan, and years later she still had the same car and had rebuilt her credit. Now, this next part is where a lot of people get tripped up and where things can go wrong fast. If your car isn't handled correctly in the bankruptcy, you could still lose it even if you've been making payments or it's paid off. For example, if your car is paid in full or has a lot of equity in it, and you don't properly claim the exemption that protects it, the bankruptcy trustee can sell it and use that money to pay your creditors. No one wants to find that out after their case is filed. On the flip side, if your car still has a loan and you don't reaffirm properly or before the deadline, the lender could repossess it even if you're current on payments. That's why it's so important to get good legal advice from someone who understands how to protect your car the right way. Filing the correct exemptions, reaffirming carefully, or choosing another option that fits your specific situation. Remember, missing just one step could cost you your car. Now, once you've filed, there are a few simple things you can do to protect yourself. Keep your insurance current. Make sure your payments are on time. Communicate with your lender or your attorney so everyone knows your plan. And if you reaffirm, make sure that agreement is properly filed with the court. When you handle this part correctly, you won't be waking up worried about whether your car will still be in the driveway. It'll be right where you left it. That's how most people manage to keep their car after bankruptcy here in New Jersey. Now, if you're thinking about filing bankruptcy here in New Jersey and you live in Burlington, Camden, Gloucester, Salem, or Cumberland County, click on the link in the description below to schedule a call with my office. Now that you know how to protect your car in bankruptcy, the next big question is usually about your home. For most people, that's where the real worry begins. They can manage losing a credit card, but losing their house? That's unthinkable. In the next video, I talk about what happens to your home when you file bankruptcy, how mortgages, home equity, and exemptions work, and what steps you can take to keep your home safe through the process. Click here to watch it now.